Hello students, how are you all? I hope you are good. Remember we were studying a subject named Corporate Laws and Compliances, under which we had started a chapter named Company Formation and Conversion. So in that chapter we had completed first topic, that is Introduction to Companies Act, where we had learned the basics of company law, and also we have learned what is the definition of company, what are different types of companies, and all the basic introduction of Companies Act. So moving forward with this particular lecture, we are going to cover today the second topic of this particular chapter is formation and conversion of companies. So what we are going to study today, first we will going to see what are the procedure and provisions regarding formation of company and how the incorporation will be done. And third topic that we're going to see is formation of OPC. Now you'll be asking that you have written formation of company and formation of OPC differently. Why? Actually the basic formation procedure is same, but there are certain additional provisions and procedure that is to be complied by OPC. OPC is one person company. We had already discussed this if you remember about it. And the last topic of this particular session will be conversion of companies. Now, starting with the topic formation of companies. Formation of companies means how the company will be formed. What is the procedure regarding it? So, starting with there is one person who is behind the formation of the company, whose name is promoter. Promoter is basically a person who is kind of a person who gets the idea of forming a company. That is, he is the person who is responsible for the idea. There is, obviously you all know, before any startup or something, there is a particular owner. For example, if you talk about Apple, you have Steve behind it. Steve is a person who has thought about forming a company name as Apple. So he is a promoter of that company. So he was a promoter of that company, sorry. So likewise, behind formation of every company, there is a person who gets the first very basic idea that I want to serve the society by this particular idea, or by selling the product, or by doing some innovation, or by planting some factory or anything. So that person is named as promoter. So first of all, I would like to tell you that I'll read this because it's a provision and you have to write this in particular in the examination in this particular format only, and these are the notes that you will be getting it, and you have to write in examination in this language only. But I'll make you understand each and every word of this slide, and you might feel that this slide is a bit technical, because in this way only you have to write your answer. But I'm going to explain you each and every word from this slide, so when you read it on your own, you will not have to face any difficulty for this. Okay, so not to worry. Starting with the promoters. Promoters, it's written here, generally person who form the company are known as promoter. That I had already told you, that the person who form the company are known as promoters. So promoters can be one or more than one. So it's not like that. So it is they who conceive the idea of forming of company. So they take all necessary steps for its registration. Means the incorporation of the company. You know, there are various procedure that is need to be done before incorporation. So who will comply with these procedure and provision? That is, they are the promoters. CA, CS, CMA, these are the professionals. They help them in following those procedure, but actually the procedures that is to be followed need to be followed by promoters. Now, according to section 2, clause 69, it basically defines the word promoter. What do you mean by promoter? Promoter means a person who is named as such in the prospectus or is being identified in the company by the company in its annual return referred under section 92. So let me explain you this point. First, this point is divided into two parts. First means he's a person who has named as such, like as a promoter. His name is mentioned as a promoter in the prospectus of the company. So when the prospectus is being given, it is issued at the time when the company is going to issue any securities in public. So at that time the prospectus is being issued, and in that this is a particular document through which the shares is being issued to the public. Okay, so this document is named as prospectus. So in that prospectus, the person who is named as promoter will be considered as promoter. Okay, then secondly, what is written? Or either he will be this person who is named as such in prospectus, or he has been identified in annual return under section 92. Section 92 talks about filing annual return. You might have known that every company need to file annual return annually since its incorporation. So what I'm trying to say is, in that annual return you have to prescribe the name of promoters. So under that section, if you have mentioned the name of any individual or any body corporate, then that persons will be considered as promoters. Okay, or second point is who has control over the affairs of the company directly or indirectly, whether as a shareholder or director or otherwise. Means he is the person who has the authority to control the affairs of the company. He may have that control maybe directly or indirectly, or either he may be a shareholder or director or otherwise. Okay, or indirectly means through debt route. If any company has taken more than 100% of its paid up capital equals to that amount of debt from any other company or any other person. Okay, means Mr. X, let's say Mr. X has given X Limited loan of 5 crore and its paid up capital is only 9 crore per se. So more than half of its paid up capital is being indirectly controlled by Mr. X. So whatever decision X Limited is going to take will be directly or indirectly may be affected by Mr. X. So in that case, Mr. X will be considered as promoter, or in accordance with whose direction or advice or instruction the board of director of the company is accustomed to act. What does it mean? Means he is such a person. Let me consider again Mr. X. He doesn't hold 5 crore, he holds 4 crore capital. Okay, the 4 crore let's say debt. Okay, he has given 4 crore debt to the company. So in that case also he may have the control by which he may give any advice or direction or instruction to board of directors of the company, and in that case board of directors are forced to act on such advice, on such direction or on such instruction. So indirectly or directly, this Mr. X is controlling the company in any or one or the other way. So that person will be called as promoter. Okay, so there is a provision to subclause 3 C. There is a provision for this. This is given. It says, provided that nothing in subclause C shall apply to a person who acting merely in a professional capacity. Means if a company has appointed statutory auditor and for example, and he is giving certain advice to director, and in that case if director is doing any act in direction with that particular professional, then that particular professional will not be considered as promoter of the company. So Please note this, or you can take a screenshot. Okay. Yeah, I'm moving forward with this. Okay. Yeah. So moving to section 3, which talks about the provision regarding formation of company. So this was the provision regarding promoters. That is, promoter was defined under the Act. So we had seen the definition which was given under section 2 clause 69. We'll revise it together. Please repeat it with me. First is, a promoter means a person who is named as such in the prospectus or is being identified in annual return, which is referred under section 92. Start remembering section from now. Section 92 talks about annual return. We're going to study it in future classes. Or promoter means a person who has control over the affairs of the company, which may be have directly or indirectly, or whether as a shareholder, director, or otherwise, or he is a person in accordance with whose advice, direction, or instruction the board of directors is accustomed to act. Okay, and remember this provision as well. Next point is section 3, formation of the company, which talks about the provision regarding the formation of the company. Basic requirements with respect to constitution of the company. That is, we had already discussed this thing, but we'll discuss in the law format. So I had to read it first and then I'll explain it to you. First is public company. Now, in case of public company with or without limited liability, means in any case, if you have formed a public company, you should have any 7 or more person, okay, can form a company for any lawful purpose by subscribing their names to memorandum and complying with requirement of the Act in respect of registration. Okay, so let me just once. So section 3, what it says, I will read it again for you. Public company, it says, in case of public company with or without limited liability, any 7 or more person can form a company for lawful purpose by subscribing their names to memorandum and complying with the requirement of the Act in respect of registration. What it means is that a public company must have at least 7 members who are subscriber to the memorandum. Subscribing their names to memorandum are called as subscriber to the memorandum. And who are the subscriber to the memorandum? These people are called as members. These are called as members. Okay, and these 7 or more people, means at least 7 people need to be there, and there can be more than 7 also in case of public company, and they need to comply with the requirement of the Act in respect of registration. What is the requirement? We are going to study in this particular lecture only. Then second is, this was the provision which is applicable on public company. Now second is private company. In case of private company, 2 or more persons are required to form a private company. So minimum 2 members are required. In case of OPC, we had already studied, it's a single person company. So only 1 person required to be formed OPC. Now, if number of members reduce below this requirement. So what is the requirement? Let me show you in brief. In case of public company, there is minimum 7 members. Okay, this is minimum. And in private, there are minimum 2. And here, no minimum, no maximum, only 7. One person is required. Okay, so if at any time this limit goes below 7, 2, or okay, then such company, if it carries on business for more than 6 months, like this only, okay, like if the 2 member left the company and this becomes 5, okay, this becomes 5 or this becomes 1, and the company is run like this only for more than 6 months, then such every member who is there in the company, like in this 5 members remain, so these all 5 members will be severally shall be liable. Okay, every member severally means that all the members are equally liable for payment of debts of the company in such a case. Okay, so let me read it once again for you. If the number of members is reduced below above stipulation, what do you mean by above stipulation? It means the above criteria which is mentioned here, that is in case of public companies 7 or more, in case of private company 2 or more, in case of OPC 1 person. So if any time it reduced below this aforesaid criteria and the company carries on its business, that is continues its business with a reduced number of members for more than 6 months, okay, means the day on which these members was reduced from 7 and or 2, okay, and from that reduction date, from the reduction date to the present date, it is more than 6 months, okay. So the company is continuously doing its business for more than 6 months from the date in which on which the member had left the company, and the limit of the member get reduced from 7 to 6 or 5, then every member shall be severally liable. Severally liable means jointly liable to the payment of the debts of the company. Okay. Now you can take the screenshot. I hope you have taken that. Okay. Now, next topic is Section 7 of in Companies Act, which says, Section 7 says incorporation of company. Section 7 of Companies Act 2013 provides for the procedure for to be followed for incorporation of company. So I was talking here that the company that they had to comply with the requirement of this act in respect of registration. So where these requirements are written, these are written on Section 7 of the Companies Act, which talks about the procedure for incorporation of company. So step 1 that is there in this, you have to file certain documents and information with registrar. Registrar means ROC. ROC, that is local. It is that ROC which comes under the your company's jurisdiction. How you will find this jurisdiction? By seeing the registered office. That is, if I want to open a company in Indore or in MP, then my ROC will be Gwalior ROC. Okay. If I want to open a company in Delhi, then my ROC will be ROC Delhi. So I need to do all the filing with ROC Delhi. But right now, it is a web-based process, so it's not that tough. When you enter the state of your particular company, you will automatically get the detail of the ROC under whose jurisdiction your company will come. Okay, and for the what is written under this, for the registration of the company, following documents and information are required to be filed with the registrar. Wherever the word registrar is given, it is ROC. Okay. Within whose jurisdiction? ROC we had already discussed, registrar of companies. Okay. So now these documents and information need to be filed with registrar, within whose jurisdiction the registered office of company is proposed to be situated. Now why the word proposed to is written here? Because your company is not yet situated or incorporated. We are following the procedure to make your company incorporated. At this point, you may or may not have the registered office. So you will get a time of 15 days to 30 days in which you can you can create a registered office and make it registered with ROC. So right now you only know the state or city in which you are going to start your registered office. Okay. So that's why the word proposed to be situated is written here. Okay. And what are the documents that are required? First is memorandum and articles. One second. Memorandum and articles of the company, which is duly signed by all the subscriber to the memorandum. Wherever word subscriber to the memorandum is written, please understand it means members. So, but they are not yet members. When they sign the memorandum, they become the member of the company. We'll study this in detail in future. But right now, for understanding purpose, let me ensure you that all the promoters or shareholders who want to have a share in the company need to sign the memorandum, and those who sign the memorandum of association, it's a document of the company. We'll study this also in detail. So who all sign this memorandum will be considered as subscriber to the memorandum, and these subscriber to the memorandum are, once they sign the memorandum, once the company is incorporated, these subscribers are called as members of the company. So what it's written, you need to submit memorandum and articles of the company which is to be duly signed by all the subscribers to the memorandum. Okay, not one, not two, all the subscribers. And secondly, you need to file a declaration in INC 8, which is going to be given by professional. Okay, who that professional will be? Advocate, CA, CMS, CS in practice, not in job. Okay, who is basically engaged in formation of the company, who is basically doing the filing things for you. So that person need to sign the declaration in INC 8, and a person who's named in articles as the first director of the company. Okay, so in articles you are going to mention the name of the first directors of the company. So the professional and the first director both need to sign this INC 8. Now what declaration you are doing under this? That is all the requirement of the act, that is Companies Act 2013, and the rules. The name of the rule is, you may note down, is Company Incorporation Rules. So all the requirement of this act, that is Companies Act and Company Incorporation Rules. Okay, the rules made thereunder. Okay, under in respect of registration and matter precedent or incidental thereto have been complied with. What does mean? Means all the requirement which is given under Companies Act and the Company Incorporation Rules regarding the registration process of the company and matter related to the registration and incorporation of the company have been duly complied with. You have followed all the procedure, and then we are this professional and a first director is giving a declaration that we have met with all the requirement of the act and rules. Okay, so we have not done any non-compliance regarding it. Okay, so first thing that we have to give is memorandum and articles which need to be duly signed by subscriber, and second is a declaration in form INC 8 that is to be given by professional and first director. Regarding professional and first director, now how will you know who will be the first director? That has been named as the first director in the article. Okay, and all the you have to declare that all the requirement of the act has been and rules made thereunder are duly complied with regard to registration. Okay, now see, third thing that you have to give is declaration in form INC 9. Who will going to give this declaration will be given by each of the subscriber to the memorandum. Okay, and from the person who is named as first director in the articles. Okay, means this INC 8 need to be given by professional and director, not by the subscriber. INC 9 need to be given by subscriber to the memorandum and first director. Okay, and what this declaration is about, that he has not convicted any offense in connection with promotion, formation or management of the company. That is, what we are doing right now, we are only doing promotion, formation and management of a company. We are incorporating a new company, so we don't want any person who has a past record who has convicted any offense regarding this. Secondly, the declaration is about he has not been found guilty of any fraud or misfeasance, that is, has done any unlawful act okay, to any company under this act or any other previous law during last 5 years. Means the subscriber and director, all these people who are giving the declaration have not found guilty or have not done any act which is unlawful to Companies Act in any previous company in which they were working or they were associated with during last 5 years. Okay, so we'll see their track record of last 5 years. Okay, so if they have done anything wrong in last 6th year, previous 6th year, then they will not be considered as like unlawful person. Okay, so this is the meaning of this. So last 5, we are going to just see the track record of last 5 years, and the unlawful act or breach of duty will be related to Companies Act only under this particular point. Okay, now what does third point will says? It says, and that all the document that is being filed with registrar, means the document that we are preparing, these lists that we are going to file with registrar, contain all the information which is correct and complete to the best of their knowledge. Means they are not providing any false or misleading information. All the information and documents and ID proofs and address proofs and everything that they are providing to the registrar are correct and complete and true as per their knowledge. Okay, so they are not involved in any fraud or something. Fourth point is, let us revise it. First, you need to give memorandum articles of the company duly signed by subscriber. Second, INC 8 declaration need to be given in INC 8. Please repeat it with me. Okay, I am not repeating just to mug up to myself. I want you to remember it. So repeat it with me. Okay, start repeating from first point A. It is memorandum and article which is to be duly signed by subscriber to the memorandum. Okay, second thing you need to file is a declaration in INC 8 by a professional and a director that declaring that you had complied with all the requirements of the Act and rules regarding registration. And a declaration in INC 9 by subscriber to the memorandum and by the director regarding these three things. Okay, what is these three things? Not convicted any offense, not found guilty of any fraud during last 5 years regarding any company, has all the document that you had filed is complete, correct and true to the best of your knowledge. Okay, and the fourth is you have to provide address for correspondence till the registered office is established. There is two things in this. If you have registered office opened on the date on which you are doing this filing, you can give the address of registered office. If not, you can provide an address of correspondence, that is a place where all the information or any letter or any notification notices can be sent to you. Okay, it's an address basically. It can be your home address as well. And D is completed. What does point E says? Particulars, that is name, residential address, nationality of every subscriber to the memorandum along with their ID proof, and in case of subscriber being a body corporate, then such particular as may be prescribed. What are these particular we discussed? So fourth point was related to address of registered office or its correspondence. Okay, and fifth point was particulars of every subscriber to the memorandum and including their ID proof. And if the you all know that subscriber to the memorandum can be body corporate, then what details are required, we'll study it now. Okay, in the rules, because it's written as may be prescribed. Wherever this word as may be prescribed is written, we need to refer rules. Okay, so company incorporation rules tells us that what kind of document that is required if subscriber to the memorandum is body corporate. First, they required a SIN number, corporate identification number. So once a company is being registered, like they'll get a SIN number, corporate identification number. Like we got a PAN number, so they got a SIN number. Okay, so we need to mention the SIN number of that company who is subscriber to our memorandum. Okay, and the name of body corporate, which is subscriber to the memorandum, the registered office address of this particular body corporate, or the principal place of business of this body corporate, email ID of this, and if body corporate is a company, then you need a certified true copy of board resolution. What do you mean by certified true copy of board resolution? BR, everyone knows it, is a resolution by which they had authorized a particular person to subscribe the memorandum. Because company is an artificial person, it cannot sign by itself. It has to authorize any director or any person who can sign the memorandum on behalf of the company. So for this, board resolution need to be passed by that company. Okay. So, but that board resolution need to be certified. Okay. And that certified copy need to be attached. Who will certify it? The two director of the company, or if the company has MD, then two director and one of whom must be MD. Okay. Now they need to specify inter alia the authorization to subscribe the memorandum. I'd already told you, and to make the investment in proposed company. What else will be written in this resolution? That they are authorizing the company to make an investment in proposed company, because they are buying the shares of that company, so they are just kind of making investment in that company. So as per the legal procedure, they also need to authorize the company by passing board resolution to make such an investment. Okay. Now, so we had filed these 5 things. Okay. First, memorandum article, declaration in INC 8, declaration in INC 9, then a registered office address, and 5th was like detail of subscriber to the memorandum, which may be individual or body corporate. Okay. And the 6th thing that they need to give is particular of the directors, who are the person who is named in the article as the first director. So what details we require from them is then there is a like corporate identification number, there is a director identification number. If any person need to be appointed as a director, he need to apply for director identification number first, and then only he can be appointed as a director in any company. Okay. So a director identification number is required, his residential address is required, and nationality is required. Okay. Like Indian or foreigner or like that. Okay. And such other particulars that may include ID proof and as may be prescribed. Now again we have to refer for rules for this, but you don't have these things in that much detail, so it's okay for you to remember only this much. Okay. And the last thing that is required is particular of interest of a person who's mentioned as first director in the article. So in future, whenever the word director, appointment or anything will come, we first of all before appointing any director, we need to check the interest of that particular director in other firm or in body corporate, along with the consent of such director to act as a director in that particular company. So these 2 things is required. There are 2 forms for this that we're going to study when we're going to study the chapter director, okay, in detail. But for now, please understand, director, first detail of directors is required to be given, is ID proof and details are need to be given. Also, he need to give his detail regarding the his interest in other firms or body corporate, because why this is important, you need to understand this, because a company deals with various other firms or body corporate, and if a director has any personal interest with that company or body corporate, then he will not be authorized to deal with such company, and at that kind of thing the other directors will decide that they need to work with that company or firm, because there may be a conflict of interest with other firm and with the company in which he is a director. So that's why this thing is being checked. And also along with this, we want consent to act as a director, that is will be given in DIR 2. Okay. And these 3 things we need from director. So particular provided in this provision shall be of the individual subscriber who are not professional engaged in incorporation of the company. So Here we had talked about the subscriber to the memorandum, we had talked about the first director. So in all these things, professionals who are engaged in incorporation, CA, CS, CMA, will not require to file anything, any detail regarding themselves. They just need to file a declaration under this INC 8, nothing else we are expecting from them. So just for revision purpose, I'm going to give you a brief that what all documents we had to file. First, repeat it with me. Memorandum article of the company duly signed by subscriber, declaration of INC 8 by professional and director. You can make short note like this, okay? And these declaration is regarding all the requirement of the Act, rules made thereunder has been duly complied with, okay? Regarding registration, obviously we are talking about registration. And third point is declaration in INC 9 from each of the subscriber to the memorandum and from the person who is named as first director. Means this is to be given by subscriber and first director regarding these three things, that he is not convicted any offense in connection with promotion, formation and management of the company, or he has not been found guilty of any fraud or misdemeanors, or not conducted any unlawful act to any company under this act or any other previous law during last 5 years, and that all the document filed with ROC contain information which is correct, complete and true to the best of their knowledge. Fourth, address of registered office or correspondence if registered office is not there. Then fifth is particulars of all the subscribers to the memorandum, whether individual or body corporate. Particulars of first director who is named as first director in articles, okay, and particulars of the interest of first director in any other company or firm or body corporate, along with their consent to act as director, okay. So there are 7 points in that. Now these are the documents that is to be given. Now from step 2, when you file all this document and registrar is being satisfied that all the documents are true, correct and there is no issue with it, then registrar on the basis of all the documents and information filed will register all the documents and information in its register, and he will issue you a certificate of incorporation in form INC 11. Okay, this is very important to remember. You have to remember this form. And when you have been issued a certificate of incorporation, your company will be considered as it is being born. It has got a legal existence. Okay, now you will be called your proposed company as a company which is incorporated under Companies Act. Okay, now on and from the date mentioned in certificate of incorporation, registrar shall also allot the company a certificate corporate identity number. As I already told you what this number is, it is a distinct identity number for the company and which will also be included in certificate. So it's a distinct identification number. From that number, when you enter that number in MCA, you will automatically get the name of the company. Okay, so it's a number which is allotted to only your company. Okay, it's a number like a membership number given to me as a CS is different from all the other CS who has got that number. So it's a kind of identity number that a company has got, and this number is written in its certificate. Now, step 4 is maintenance of copies of all the documents. Now, the company shall maintain and reserve at its registered office the address which is given under that particular filing. Okay, all the documents and information which is originally filed to ROC at the time of incorporation. Now, how long you have to preserve it? You have to preserve till the dissolution under this act. That is, till winding up, you have to preserve these documents. Which documents? Again, I will repeat. MOA, AOA, that is Memorandum, Article INC 8, INC 9, the ID proofs, address proofs that you had provided while registering your company. Okay, so all these things you need to preserve till your company gets dissolved. Okay, permanently you have to preserve. And also this certificate of incorporation, you have to preserve it permanently. You can called it as permanently. Okay. Now other important points is furnishing of false or incorrect information. Now what will happen if you given the false or incorrect information while incorporating a company? So we're going to study this in the next video. So till then, keep revising. Revise everything in 24 hours. This was a very important part for the purpose of your examination and knowledge purpose as well. So please, you can again watch this video and you have to revise it at least once or twice before watching next video. Thank you. Bye-bye.